For today's briefing on the IT rules 2023, which basically brought in gaming, real money gaming. Sorry, I shouldn't confuse things by calling them games. They've got real money games under the regulatory ambit by treating them like intermediaries. So we're going to talk about that. We'll also, so Aarti and Sarvesh have been doing much of the reporting on real money gaming, including a great story they've done together, I think 6-8 months ago on suicides and addiction in Tamil Nadu. They've been following these regulations for a while. So they're going to run you through the key issues in these regulations. We held a discussion on this in Jan as well, which was one of my favorite discussions because it got really heated and charged, and it was a great debate. So that video is on YouTube, publicly available if you haven't seen that already. And then I'll talk about the easier thing, which is about the speech regulations related to fake news. We'll take your questions towards the end of these presentations. So, and the Q&A is going to be off record. So that won't be available as a recording later. So we can have a free-flowing conversation. So please keep adding questions in chat and we'll address them during the Q&A. If you want to come on and speak about it, please raise your hand and we'll bring you in towards the end. That's an open conversation that we have at the end of the briefing calls. So I'll hand it over to you, Sarvesh, or Aarti. Aarti, you want to start?
Sarvesh, if you can just take us through the housekeeping before we start.
Yeah. So just quickly, this is should not be considered as legal, business, or investment advice, and our information is selective. We'll be covering a wide range of topics today. I won't pinpoint each one of them, but roughly the online gaming rules issued by the center. This is the IT rules amendment 2023. Then the Tamil Nadu Gambling Act, which was passed the very next day. And also the fact-checked amendment, which is one provision in the IT amendment rules 2023. So these are the three things we'll be covering. And most of these questions will be answered either throughout the presentation or as part of the Q&A. Aarti?
All right. Thank you so much, Sarvesh. Everyone here, I have audio issues with my laptop. So if you can't hear me at any point, please let me know. So this is just a quick run through of the online gaming rules and also how they compare to the version that was released in 2020, in January earlier this year. Next slide, please. So the big question that's on everyone's mind is, are gaming platforms still being called intermediaries under the rules? And the short answer here is yes. The rules define online gaming intermediaries as platforms enabling the use of computer resources to access one or more online games. And online games definitions have also seen an expansion with the 2023 rules. Aside from just a different definition for online game, we also have different kinds of games being introduced, such as online real money game, permissible online games, and permissible online real money games as well. And we'll get into the differences of those later on in the presentation. This is somewhat different from what we got in January, where we just sort of had a stock definition of online gaming intermediaries and online games themselves. Those two things were sort of ambiguous at the time and raised more questions perhaps than they answered. But I think some of those questions still actually remain even with the expansion under the notified rules. For example, if you're looking at the question of gaming platforms themselves, they've often been typically held to be publishers who are actively creating and publishing games online. So can they actually be considered a third-party conduit, which is what an intermediary is? And as a result of that, can they be regulated by the intermediary guidelines or the IT rules, so to speak? And it's also important to remember that the government has clarified that publishers are not included in the definition of intermediaries under the IT Act in Parliament. So key question there that's yet to be answered. The second thing is essentially how are large casual games covered under the rules? And for those who aren't in the know, casual games are essentially video games that are offered to a wide range of audiences. There are no specific definitions for casual games listed in the rules, but it's likely that due diligence obligations for online gaming intermediaries offering games could be applied here to regulate these games. And it's also likely if there's a real money element involved, then the additional due diligence obligations coming under Rule 4A may also apply as well. However, the most important powers here that perhaps are relevant to casual games perhaps might be the government's powers to notify non-online real money games and to basically say that they should observe online real money games due diligence obligations. And the grounds to do that are perhaps vast ranging, including protecting India's sovereignty, friendly relations, and preventing user harm or anything that's essentially detrimental to users. Next slide, please. And these powers were included in the January proposal as well. However, harm was a little more explicit there. They talked about causing addiction or causing harm to children. And that sort of has been diluted a little and made a little more ambiguous and broad with the current provision as well. Two questions that remain as a result of this is essentially how do platforms that are eventually notified to follow online real money games obligations, how will they actually be impacted? Do they have the financial, the logistical resources to comply with all that extra regulatory, excess that comes with it? And also, will the government be transparent about how these games are notified? Yes, it will come through the Gazette, but will the public and will businesses get a full lowdown of why certain games are considered harmful or a threat to India's sovereignty? So those are two questions that remain as of now. And then, of course, the bedrock of the rules themselves or the regulatory function really lies in the hands of self-regulatory bodies. As we all know, self-regulatory bodies will essentially take on members, which are gaming platforms who have a history of offering online games reputably. They will also have a board of directors and basically be responsible for verifying games and ensuring that they're kosher and safe and don't hurt people before they hit the Indian markets. And there are various parameters that these bodies will be looking at when they're verifying online games. And I think the most important and significant one, which we'll touch upon later, is essentially that it should not involve any wagering on any outcome. Only then, that's a huge parameter when deciding whether a game is safe or not. And of course, addressing competition concerns that were raised back in January. Now the rules, the SRBs are essentially allowed to provide a temporary approval to permissible online real money games for 3 months. And within that 3 months, they can essentially figure out whether the game deserves a permanent stamp of approval. And this perhaps comes after concerns that people were worried that a long verification period might hurt competitive advantages. And again, a bunch of other points that SRBs have to keep in mind while verifying games include protecting children's interests, protecting against various kinds of psychological, and financial and territorial harms as well. And the SRBs have to keep a list of these verified games, communicate them with the ministry, and then also provide reasons for why they were verified. And that information is what the government will then use to eventually block, if it has to, an online game under Section 69A of the Information Technology Act. And of course, the usual stuff, SRBs have to have a grievance redressal framework, and they'll also be given the chance to be heard by the IT ministry and rectify any errors if the IT ministry finds that an online real money game doesn't conform with the IT rules. But of course, the IT ministry also has the powers after a necessary hearing to revoke or suspend an SRB's registration. So the proposal sort of remains somewhat similar to what was given in January. However, there are a couple of questions that still remain. Key one is essentially whether the SRP's powers to verify games as kosher encroach on state powers to regulate online gaming and gambling. As we all know, online gambling is a state subject. And here we're kind of seeing a dual or parallel track of regulation where SRPs are also being given the power to determine what's essentially a wagering game or what's not. And it's likely that that could perhaps lead to some amount of regulatory friction where even a game that's verified by an SRP might find itself banned in a state based on that state's gambling law. And it's a friction that the gaming companies and the IT minister seem to be aware of. And also, it's just a simple question of how will the SRB even be determining what wagering means in the first place? And people have written about this on MediaNama as well. The rules don't include a definition of what wagering is. So the discretion of determining that lies entirely with the SRB. And again, there's the question of what if a game that's otherwise been held to be legal in India gets determined as to be a wagering game by the SRB? What happens then? And what happens to this confusion over the legality of game formats that India currently has? On a similar vein, how will the SRBs define and sort of set a standard for harm when there are so many different definitions of it cropping up across the rules? And also, sort of equally important note, how will members of the SRB challenge and appeal SRB decisions? Aside from just sort of, a dodgy game that might have been verified, which I spoke about earlier, what if a smaller company or any company wants to challenge the SRB, what's the appellate mechanism in that case? And perhaps finally from the industry folks, if you'd been interested in the Q&A session to touch upon what are the benefits of light touch regulation. It's been celebrated, the rules for being hands-off, but I'm just curious to know why that's a good thing, genuinely. And also I'm curious to know whether, as people have accused, this is a delegation of responsibility from the government by putting everything in a private SRB's hands. So that's essentially how the SRBs will be regulating the sector. And of course, there's another big question that we have, which is how are gaming platforms supposed to verify players' identities? And right now, what we essentially see is that platforms will have to verify identities before they accept cash or kind while playing a permissible online real money game. And that verification will have to be an RBI-level KYC. That's different from what we saw in January, where they said the RBI-level KYC comes in when you're just making an account. And the January proposal saw some concerns. People were worried that it could hinder players trying to simply get a feel for the platform by creating an account. So that is an improvement in that sense. My question is, does that concern remain with the current amendment? Is an RBI-level KYC simply too stringent for a normal deposit on an online real money game platform? And there's also the fact that KYCs come with data privacy risks as well. You're connecting a large amount of financial information. So do those do those risks and harms get regulated for under the rules, or does that happen elsewhere? And finally, what problem is RBI-level verification solving here? Is that level of stringency necessary? What are the harms or the financial harms that the government and the industry has defined or is identified that requires this level of protection? There's also the question of how children are protected from harm, and the story that Nikhil was referring to, that Sarvesh and I did, essentially spoke a lot about how kids are deeply addicted to platforms and how they struggle to get off them. So the rules do address that tangentially. For example, intermediaries cannot host any games that cause user harm, and here harm is interpreted to mean anything that's detrimental to a child. When verifying games, they also have to look at whether the games contain measures to safeguard children's interests, and they're also exploring the option of age rating mechanisms for games, etc. But like I said earlier, there are definitions of harm that crop up across the rules. We see it in the case of due diligence obligations. We see it in the case of verification. So as was the case in January, the question still remains, what is the standard and benchmark for harm that SRBs will essentially be looking at when they're verifying these games and ensuring that kids are protected on the internet? And of course, the rules have also been spoken about in a celebratory tone when it comes to the question of offshore gambling, which is essentially gambling that is online gambling offered from websites that are registered outside of India. And the skill-based gaming industry in India has seen the rules as a sort of positive step towards addressing this issue. From a platform's perspective, there are two ways in which the rules exactly does that. The first is essentially intermediaries, like I said earlier, cannot host online games that are not recognized by self-regulatory bodies. And a self-regulatory body would never recognize a game that involves wagering or betting. So by doing that, you're essentially removing the scope to host these games. And the second is also intermediaries cannot publish ads, surrogate ads, or promotions for non-permissible online games. And the same argument applies here. And I think the government's seriousness or awareness of this issue really comes through with the fact that they've issued multiple advisories to different media platforms over the past year, including one the day these rules were notified, essentially saying that please don't host these ads for online betting and gambling platforms. And these were issued to all sorts of digital platforms and print platforms as well. So ultimately, the question becomes, what next for gaming law? There's a lot of improvements, but a lot of questions still. The biggest one is essentially the legality of the amendments. A lot of people have questioned the fact that so many changes are being introduced through subsidiary legislation like the IT rules, and whether that's legal in the first place. However, some have also noted that it's unlikely that these may be challenged in court by stakeholders within the industry. The second is essentially, outside of the rules, what is the larger regulatory cohesive approach to address this sector? The first is the a future pan-Indian online gaming law, which will essentially, with the consensus of states, regulate the sector across the country. To do that, you need to trigger a constitutional amendment to bring gaming, gambling outside of the state's regulation. So the question some experts told us is that's important to ask here is, where is online gaming important enough to actually do that? And finally, of course, we have the Digital India Act, which Nikhil was speaking about in his introduction, which may tentatively, for now at least, separately regulate online gaming intermediaries, because they're a separate class of intermediaries under a different kind of rule. And the warning, which Nikhil has written about as well, is that the Act may actually create the grounds to justify these rules post facto, which could be a concern just when we're looking at the legality of lawmaking. But I also think it's important to look at Mr. Chandrasekhar's comments on safe harbor and what the Indian internet could look like without safe harbor or limited safe harbor. And so, of course, in this context, maybe we can discuss it later. How would the online gaming industry survive or exist or adapt without safe harbor online? So that's essentially a roundup of the rules and what we can expect going forward. And now Sarvesh will take us through the Tamil Nadu online gambling law.
Thanks, Aarti. So a day after the center notified its online gaming rules, so on April 7th, we had Tamil Nadu's governor giving assent to the act banning online gambling in Tamil Nadu. But this actually traces its way back to 2020. And the bigger picture here, the bigger context here was there was a bunch of suicides linked to gambling. So essentially players borrowing money to gamble and not being able to repay, and in turn committing suicide. And this led to a lot of political pressure for the government to act. And so what the state government did back then, the previous administration, they amended the police laws and banned all kinds of online games. It could be games of chance, games of skill. It didn't differentiate any of these. Everything was banned. And for this reason, the Madras High Court struck down this law when it was challenged. The High Court gave two reasons, basically. It said, one, you're trying to regulate games of skill, which you cannot. And two, it doesn't look like you've done enough research on the necessity and the proportionality of this law. Tamil Nadu challenged the Madras High Court's decision to strike down the law in the Supreme Court, and that is ongoing. But parallelly, what the government did was it set up a committee led by Justice Chandru, and this committee was tasked with studying a new law, coming up with a new law. And the main aim of this committee was to address the second point raised by the Madras High Court, that you haven't done enough research. So this committee was supposed to be doing that research on how online gaming is harming students, children, and why a law needs to ban it. And eventually in October last year, Tamil Nadu came out with a new law, and it sent this law to the governor for assent. Due to internal politics within the state between the governor and the ruling party, the bill was delayed for quite some time, and it did not get the governor's assent until April this year. What does the TN Gambling Act ban? Basically, it's all kinds of online gambling, and built into the definition of online gambling is any online game of chance for money or other stakes. The bill actually also defines game of chance, and there's a lot of parameters, but whenever the chance is higher than the skill proportionate, or whenever only superlative skill can beat the chance, so all these are considered games of chance. Apart from banning all games of chance, it also has another category which it says are games of chance specified in the schedule. This schedule is something that the government can update with new games, but right now it has rummy and poker in it. And the reason for creating a separate schedule and banning games under the schedule is because rummy and poker might not be traditionally considered as games of chance, but TN government wants us to know that over here we are considering it game of chance and we put this in the schedule. So gaming platforms should not provide any of these games in the schedule and any of the other game of chance. Advertisements promoting these games are not allowed on any forms of media. Banks and payment gateways are prohibited from providing these services to platforms that offer these prohibited games. The law also sets up something called the Tamil Nadu Online Gaming Authority, and this authority will have 5 members. The main functions include like regulating online games, so they can come out with new rules and regulations on time limits that these games must impose, monetary restrictions, for example, how much money can be deposited in a month by a single user. So around those kinds of parameters, this authority can come up with rules. And it also has the function of issuing certificates to local game providers. We'll get to that in the next slide. So essentially, the law classifies gaming providers as either local online gaming providers. These are companies that have their central management or control in Tamil Nadu, or whose service is hosted in Tamil Nadu, and non-local online games providers, which is everyone else operating in India. When it comes to local online game provider, they can only operate if they get the certificate from the authority. And to get the certificate from the online gaming authority, they have to have fulfilled certain criteria. When it comes to non-local providers, they don't need the certificate, but they are required to ensure that they do geo-blocking of banned games for citizens of Tamil Nadu. And there's also a list of due diligence they have to take, measures that they have to implement. For example, they have to notify their users that if it's a Tamil Nadu user, they have to notify the user saying that this game is banned here, you cannot play this. It has to collect enough information to judge if that player is playing from Tamil Nadu or not. So all these fall under the due diligence requirements for non-local providers. If for non-compliance with these rules, there are many categories, and users also can be charged with non-compliance. So if I'm a gamer in Tamil Nadu playing a banned game, I am subject to 3 months of prison and or a 5,000 rupee fine. Then there's a penalty for illegal ads, penalty for gaming platforms if they host the prohibited game. And if a local provider is in contravention of the law, the certificate given to them can be cancelled. But when it comes to non-local providers, just because the state cannot directly exercise control over them, the way it works is the state will ask the center to block that game under Section 69A. It's up to the center to either comply with that or not. That's the penalty for non-local providers. Why is rummy and poker considered games of chance for Tamil Nadu? Historically, we've had multiple high courts and the Supreme Court rule that poker and rummy are games of skill and they should not come under gambling. This is why a lot of the state bans, Karnataka state ban, Tamil Nadu state ban, many of these bans were overturned because they tried to regulate these games. Now what Tamil Nadu is arguing is it's saying that these games, when played online and when played offline, are two different things. Maybe offline they are games of skill, but when it comes online, it is it's a game of chance because there's a lot of randomness involved, and the random number generators that are used by these platforms are not really random. We cannot audit them. We don't know what exactly is going on behind these platforms, and there's also an addictive design to this entire the way these platforms work. For all these reasons, we think it's a game of chance. Of course, this is likely to be challenged by gaming platforms. We already had AIGF challenge these back when it was first announced back in October, but since the law wasn't in effect, the petition was withdrawn, but they can challenge them again this time.
Yeah, this algorithmic accountability bit, actually, Vishal Gondal had raised it on MediaNama, I think maybe some 2 or 3 years ago in a guest article that he'd written. Vishal's well, he used to be the founder of India Games. He now runs a health tech company called Goki, but he wrote about the lack of algorithmic accountability here and how these are not necessary. Basically, it's not a level playing field. It's like the house always wins is what he titled. So please go and take a look at that article. It went a bit crazy. I think a lot of companies responded to it. There were there was like a legal attack on him. Like Vishal got lawsuits and or the legal notices from random parts of the country from people saying that they're users of these games, and essentially on the basis of the article he wrote on MediaNama, I think, I don't know if there any FIRs were filed, but there were threats of FIRs being filed. Aarti just put a link to that. But he raised the issue of that algorithmic accountability first in this domain. So I think it's that conversation anyway has to happen across the board. Because there is one discussion. I think Sarvesh, you mentioned it to me once, that there's a case in the Supreme Court in the US, I think, or there's some discussion happening in the US also about whether because there are people who are writing algorithms and algorithms are determining what gets shown, does safe harbor exist for them anyway? So that's an interesting debate to have in the context of games. Sorry, back to you.
Yeah, the other big question that we have, like something that's for us to look forward, is not look forward exactly, but something that we might expect is state versus center, this battle between state versus center on who gets to regulate what. Just a few days back, IT Minister for State Rajiv Chandrasekhar, in a Twitter Spaces conversation, he talked about how it's meaningless for state government to try and legislate for things happening on the internet. So he basically suggested if it's online, if it's gambling offline, it's in the state's ambit. If it's gambling online, then it's under the center. And he also specifically pointed out that the Tamil Nadu Act is too complex in how it differentiates game of skill and game of chance. But on the other side, we have the Tamil Nadu government and the Justice Chandru committee. Justice Chandru himself had, a few days before Chandrasekhar's comments, he had said that if this has to go to a legal battle, the state will take it, because for Tamil Nadu, banning online gambling is the only way to regulate the sector, and it's not going to rely on center's rules to help on this front. It's just going to be doing its own thing. Yeah, that's about it for the Online Gambling Act in Tamil Nadu. Over to you, Nikhil, for the fact check.
Thanks, Harvey. So essentially, this is a redux of the amendment that had been slipped into these IT rules amendments in the past, where right towards the end, they wanted to make the PIB, the Press Information Bureau, responsible for fact-checking and taking down content on social media. So because there was a lot of criticism of PIB getting that power, it looks like one solution that the government has come up with is to say that they'll create a separate body for regulating what they say is fake news on the internet. So there has still been a bunch of criticism on it. There has been a case that's been filed by Kunal Kamra. We'll talk about that. But a couple of words to pay attention to over here, which is that in respect of any business of the central government is identified as fake or false or misleading by a fact unit of the central fact check unit of the central government. And they've said that they haven't defined what the constituent of that fact checking unit is going to be. But the onus is on the intermediary essentially to take down that content, because they're saying that if they won't have safe harbor, which means that they will be liable for that content if they don't take this content down. Now, if you go back to what is happening in 2013 and 14, actually not 13, 14, but maybe 11 and 12, Rishabh Dara had done this fantastic research report when he was a Google scholar, where his research indicated that intermediaries were essentially willy-nilly taking down content on the basis of a complaint. At that time, before Shreya Singhal, what had happened was that anyone could write a letter to an intermediary, and therefore it would be brought to their notice that certain content could be illegal, and that if the intermediary did not take down that content, then they would basically face the liability. So most intermediaries at that point in time were just trigger happy because they didn't want to consider liability They didn't want the liability, and they were taking down that content. The same, and so in Shreya Singhal, one of the things, and I was in court for most of that case, there were several arguments against this because of the definition of the term actual knowledge. So in this case, basically, and what the court ruled was that there could be a government order to take down content, or there could be a court order to take down content. Both are mechanisms of actual knowledge, which means that any random person sending a letter does not count anymore. In this case, there's a fact-checking unit of the government that is going to be issuing an order, and the impact is going to be the same. No intermediary can actually survive losing safe harbor on the basis of a government fact-checking units thing. So even though Rajiv Chandrasekhar has gone in public and said that this is not censorship, this is just taking down of, this is just that intermediaries will lose safe harbor, it has the same effect as censorship. It's the same thing that they're weaseling around with end-to-end encryption in the rules, where they say that you have to determine the originator of a message. It's not a privacy issue. And so we don't want to break end-to-end encryption. We're not saying you should break end-to-end encryption, but you need to be able to identify the individual. Whereas the effect is that the moment you modify the end-to-end encryption structure, whether in Signal or in WhatsApp, and you are able to, and you start identifying, it breaks end-to-end encryption. So the effect is the same. So the government is saying, we're not doing this. We just need this information. In the same way, we're not censoring, but we want you to, you will just lose safe harbor. The effect is censorship. So there has been criticism, the standard one about a chilling effect on free speech. The government has given itself power to determine what is fake or not. In fact, Rajiv Chandrasekhar has gone out and said that the government is the best entity to determine whether the reporting on the government is accurate or not, because they have more access to information, and only they can do fact checking for the reporting on the government. Of course, the reality, and I can tell you that as a media person, is that our job is to call truth to power. Our job is to fact check the government. So if fact checking of the government gets taken down by a government fact checking unit, what do you do? There's also obviously no definition of what is fake or false. In fact, incorrect information is not necessarily illegal. And historically, what we've also been seeing is that if you look at PIB's PIB fact checks updates online, most of their censorship or most of their fact checks are political in nature. So we know we're heading into an election year. We don't know how this is going to work out. We will actually see the extent of the activity of this fact check unit only as we move towards maybe December, Jan, Feb, because elections are going to be in March and April. But what you're also seeing is that earlier social media platforms, this is also a transference of the balance of power. So if you look at Rajiv Chandrasekhar's statement over here, it's saying that the social media platform shouldn't be playing the arbiter of truth. But what in effect it means is that the government will be the arbiter of truth. So what's happened is that the balance of power has shifted from users to platforms, and now it's shifting from platforms to government, and giving them more power. So he's, again, so the point about the fact that independent fact checkers can't do it because they don't have necessary information about government data. What this is also nudging towards is basically a self-regulatory organization being set up by social media platforms. Some had been in favor of it. Some of them had been against that idea. When the GAC, which was set up in the previous IT rules amendments. And frankly, all of this so far is an outcome of the failure of social media platforms to challenge the government in court. The only entities that have challenged the IT rules 2020, where this process first began, were news organizations, because of which the applicability of a censorship rule, Section 69A, which is a secret government blocking power, which is typically only applicable to intermediaries, but in the 2020 rules, they expanded that to include news organizations as well. So LiveLaw was the first to go to court and challenge these, and eventually another organization went and they got a stay order. So Section 69A, which was media censorship, was not allowed because of because of a court stay order. They're trying to bypass that with these amendments, saying that, hey, even if it goes up on your website, we can always kill the reach by regulating intermediaries. And also effectively, they can still regulate ISPs and ask them to block the same content. And so, the effect, what was blocked by news organizations going to court and then has been overturned in a sense with this fact-checking rule. The other is that there has been so the other is that, let's say, the social media companies have failed to challenge. WhatsApp went to court to challenge the end-to-end encryption issue because that was an existential crisis. But all of this began with the idea of personal criminal liability for the chief compliance officer of significant social media intermediaries. No company wants their employees to go to court. So now there is a sword hanging on their above their heads, and no matter what happens, the moment they get an order from the government, they will comply. And the only way of stopping this is if they go to court. Had they gone to court initially, multiple amendments, which are all largely illegal, including this one, because they're not allowed by the IT Act. These are not due diligence provisions, would not have happened. And so that's why and the same thing, like last month, Anurag Thakur, the Minister for Information and Broadcasting, talked about more regulations for streaming services. Streaming services did not go to court to challenge the IT rules when they first came out. They accepted the compliance framework. So what you're seeing is an outcome of inaction from the industry, and the only parts which have remained intact or which have basically been stayed in courts are the ones where people have gone to court. Everything else, the government has basically kept evolving these rules. One of the things I want to flag to you is that this is going to happen with the Digital India Act in all probability. If you see the construct of the data protection bill last time, it moved everything to rule making, to delegated regulation. And so what will happen is everything in the data protection bill will be broad because the government will want to be in a position to create regulations as they go along. That's what we're seeing with the IT rules, except in the IT rules, the rules are preceding the law. So the rules are here, and whatever changes we've seen since 2020 in the IT rules, you can expect that those changes will be legitimized through the Digital India Act by overriding the IT Act. And the IT Act will also give the government the necessary powers to make rules freely. So what you will see is that every time the government spots a gap, every 6 months, every 7 months, they will start amending, they will start creating more and more rules to regulate the internet. That creates an uncertain environment, that creates a lack of the stability which a law provides. So we're going to see this going forward. I know I've gone on and on about stuff other than these rules, but one of the stories that Soumya did in the Indian Express, and Soumya used to work with us, he's done this great story where he's identified that the constituent of the fact-checking unit are going to be someone from the IT Ministry, Statistics and Program, a so-called media expert, and a so-called legal expert. So there's going to be an appeals process over there. There's going to be a public, publicly they're going to display which content has been flagged and what has been censored. But the fact is that this committee is still going to be a government committee. Their appointments are going to be government determined. It's not an independent body, really. It is still censorship. And even if they're censoring government, like fact-checking government-related content, there's nothing in these rules that prevents them from fact-checking other content. So what they're saying right now is what they're saying, but we'll see what happens when it comes to the way they're acting. So these are issues that we're going to see play out further in IT laws, where you will see more aggregation of power by the government over the industry. I know that the gaming industry's welcomed these rules from a gaming perspective, but effectively they're also enabling the illegality of parliamentary processes. And so they might be okay with it now, but there will be other rules where now that you're legitimizing this process, you will see much worse. So what they're doing is that they're welcoming it in the short term, but you're essentially creating a norm, which is problematic. So for governments not following processes is not new, but when they don't follow processes, it should be challenged. So I'm glad that at least from the fact-checking perspective, Kunal Kamra has gone to court and has challenged these rules. And let's see what happens, right? So what we saw was immediately in court that the secretary or the person in attendance basically said that there will be a further notification that will come out, which will define who's going to be a part of this committee and more details on the process that will be followed. And so the government might try and assuage the court on the basis of putting in checks and balances on the fact-checking unit. If you go back to Shreya Singhal, at that time, the Supreme Court had upheld 69A, which was the secret blocking powers. And we've only had 2 instances where the secret blocking powers have not been secret, maybe 3, 4 instances. The first 2 of which were, first 3 of which were the blocking of apps of Chinese apps, where the government actually issued a press release about a 69A action. And then subsequently, the Ministry of Information and Broadcasting has been issuing press releases about blocking, YouTube channels under 69A. The question is that we still don't have transparency and accountability on the stuff that is being censored behind the scenes, stuff that we don't know about. And like I said, I think it's a failure of the industry to not challenge the illegality of these rules. In some cases, civil society also needed to do so, but there is very little civil society to speak of. And I guess IFF is doing whatever it can. So is SFLC. So we'll stop recording now. Rakesh, can you stop recording, please?